Okay, welcome to the recorded lecture about civil liberties. Let's get right to it. Most important thing about civil liberties is to make sure you can distinguish between them and civil rights, and most people can't do that. So let's start by talking about what civil liberties are. Civil liberties come right out of what John Locke was talking about when he talked about inalienable rights or natural rights. The rights that God gave to man, inalienable rights that no government could deny. And so when we talk about civil liberties, the idea of these inalienable rights goes all the way back to John Locke in the 16th century. It goes all the way back to the Declaration of Independence, and it goes all the way back to the founding and the founding documents and the first 10 amendments added to the Constitution in order to gain ratification of the Constitution were all about civil liberties. Civil liberties are those areas of personal freedom that are protected from government interference. There are actually two dimensions to civil liberties. They are substantive and procedural. Substantive means simply that there is a list of freedoms in civil liberties in the Bill of Rights, limits on what government can or cannot do. For example, in the First Amendment, it says that Congress shall not establish an official state or national religion. The Fifth Amendment says that the government cannot seize private property without compensation. And so a lot of what we find in civil liberties are specific prohibitions on what the government cannot deny to the people. Some other substantive limits include free speech, a free press, and the right to bear arms, and others. After substantive are also the procedural rules. The procedural elements of civil liberties are the rules regarding how the government has to act. And this is very important because the government can deprive you of your life, liberty, or property. It can deprive you of your life, liberty, or happiness as well. We know that. Government arrests and tries and convicts and executes people all the time in this country. But what the procedural protections mean is that they can only take those things from you. Take your freedom, take your liberty, take your property, take your life, if they afford you due process. And so the rules regarding how the government has to act in order to enforce the law guarantees that you will not be deprived of any of those inalienable rights without getting due process of law. And the due process amendments are the 4th, 5th, 6th, and 8th amendments of the Bill of Rights. So civil liberties in general, the idea behind them is that the minority is protected. They can speak and act as they desire, even if it offends the majority. And that's why the documentary For the People, I think, is so important when it looks at the issue of school prayer in 1963. It was an enormously unpopular decision by the Supreme Court in 1963 to forbid state-sponsored prayer in the schools. However, the protection was for a minority who did not feel they should be compelled by the state to pray. Civil liberties are also the national means to protecting a marketplace of ideas. And you need to have a free marketplace of ideas in order to have a healthy democracy. Civil liberties allows everybody to have their say, to speak their minds, to talk about their preferences, and nobody can be gagged based upon the content of their speech. The notion of a marketplace of ideas is that all ideas are welcome in the marketplace. Some will be embraced and lifted up, and others will be rejected. So that even if you don't like the Nazis or the National Socialist Party, they still have First Amendment rights in this country. And then the notion of the marketplace of ideas is that if their ideas and their speech is really abhorrent, it will be rejected in a marketplace of ideas. And finally, civil liberties allow people to live the way they want to live, as they choose to live. And so, again, they go all the way back to this notion of inalienable God-given rights that Locke talked about and that we saw in the Declaration of Independence. Now, we know that the convention concluded without a Bill of Rights. The Federalists, who were led by Alexander Hamilton, argued that that wasn't necessary, that because the national government was only given specific delegated powers, and because each of the 13 colonies at the time had their own Bill of Rights at the state level, they were pretty comfortable walking away. And Hamilton basically summed it up by saying, "For why declare that things shall not be done, which there is no power to do?" But of course, what we know now is that in the price for getting the Constitution ratified was to appease the Anti-Federalists and to lay out these specific civil liberties that would be protected for the people, for the states, against this very large, powerful national government. When we talk about civil liberties, they are not all in the first 10 amendments to the Constitution. In fact, 3 of our most important civil liberties are mentioned in Article 1, Section 9. And the first of those is habeas corpus. The guarantee of habeas corpus is basically a promise that government cannot detain you or disappear you, take you away from your home, or deny you your life or your liberty without due process of law. And part of that due process means they have to bring you before a judge and tell you in public why you're being held. Habeas corpus is Latin for bring the body. And it is a promise that no one will be disappeared in this country. That if the state finds a reason to take you, to deprive you of your freedom, you will have your day in court. You will have your day in public, at which time the government must explain why you have been denied your right to freedom. Article 1, Section 9 also prohibits bills of attainder. Now, bills of attainder are kind of a quaint notion, and of course the reason we don't talk about them much today is because they're prohibited. But bills of attainder are essentially laws that declare an entire group of people guilty without a trial. And again, it seems why that's ridiculous, and it is, but there had been a history in which entire groups of people were declared guilty of a crime, either through association or through membership in some group. And that's what a bill of attainder is. And they are prohibited by the Constitution, and they are a civil liberty that are not in the Bill of Rights, but in the body of the Constitution. And finally, there's a prohibition on ex post facto laws. Again, this is an antiquated notion, but it essentially means that the government can't pass a law tomorrow that makes something you did today illegal. If it's legal today and they change the law tomorrow, they can't come after you. That's what ex post facto means. Those are the 3 most important civil liberties that are not in the Bill of Rights. Now, there is also the prohibition against acceptance of titles of nobility, and Article 3 guarantees trial by jury in a state where the crime was committed. Article 3 also defines treason. But it's important to note that the first 3 are very important civil liberties that are granted not in the Bill of Rights, but in the body of the Constitution. And so, again, we know that the Anti-Federalists were concerned about the potential for government abuse of power, and the Federalists agreed to the Bill of Rights. The House of Representatives adopted 17 amendments. The Senate adopted 12 of those amendments, and of those 12, only 10 of those amendments were ultimately ratified by the states, and those 10 amendments are called the Bill of Rights. So in addition to the civil liberties in the body of the Constitution that we just talked about, civil liberties are also included in the first 10 amendments. This table gives you an idea of specifically which elements of the Bill of Rights placed limits on what elements of the government. For example, First Amendment, Congress cannot make any law establishing a religion or abridging freedoms of religious exercise, speech, assembly, or petition. That's a specific limit on Congress. There are also limits on the executive, limits on the judiciary, and limits on the national government. So that is one way of looking at the 10 amendments, but we're going to take a look at them one by one. But before we do that, we need to talk a little bit about the history of civil liberties in this country and the Bill of Rights in particular. We know that the Bill of Rights were ratified by the states, the first 10 amendments to the Constitution, which make them part of the Constitution. But at that time, the Bill of Rights only limited the federal government. It only applied to the federal government. And so in 1833, in the case of Barron versus Baltimore, the Supreme Court ruled that the Bill of Rights only limited the action of the federal government and not the states. The case in Barron versus Baltimore was a case of eminent domain. The Fifth Amendment prohibits the government from taking property without just compensation. That's called eminent domain. And in Baltimore, an individual felt that they had been denied their eminent domain rights, and they went to the Supreme Court, and the Supreme Court said that that protection only applied to the federal government, not to the states and not to the city of Baltimore. And so in 1833, the protections of the Bill of Rights were only limited to the federal government, not to the states and the localities. After that, we fought a civil war, and the Civil War, to a large extent, ended up creating the mechanism for nationalizing the Bill of Rights. That is, making the Bill of Rights applicable not just as to the federal government, but also to the states. Because, of course, we know that slavery was an issue that was fought over in the Civil War, and that the southern states had slavery, and even after the Civil War continued to discriminate against African Americans. And there was a sense following the Civil War that an amendment to the Constitution was necessary to prevent the states from violating the civil liberties of their people. And so after the Civil War, we had three important amendments. The 13th Amendment, which abolished slavery. The 14th Amendment, which has three clauses, and we're going to talk about it extensively. And then the 15th Amendment enfranchised African American men. But for now, know that the 14th Amendment is the mechanism that applied the Bill of Rights to the states. After the 14th Amendment, it wasn't until 1897 when the Supreme Court ruled that the Due Process Clause of the 14th Amendment applied to the states, and it prohibited states from taking property for public use without just compensation. So in 1833, in Barron versus Baltimore, they told the plaintiff that he was out of luck, that Baltimore wasn't bound by the Bill of Rights. In 1897, they finally incorporated that protection to the states. By 1925, the Supreme Court ruled that freedom of speech also applied to the states. Not only could the federal government not deny you your freedom of speech, but the states were also prohibited from doing so. But the court did place some limits on the expansion of civil liberties under that 14th Amendment. In 1937, in the case of Palco versus Connecticut, they ruled that the prohibition on double jeopardy, which is in the Fifth Amendment to the Constitution, was not going to be incorporated to the states. They said that instead, only the most essential liberties would also be applied to the states, and that would be done on a case-by-case basis, which became known as selective incorporation. And so selective incorporation means that there was no single moment when every element of the Bill of Rights was suddenly applied to the states. It happened over a long period of time, and it happened on a case-by-case basis. And that's what selective incorporation means. It wasn't until 1969 in Benton versus Maryland that the Supreme Court overturned Palco and incorporated protection against double jeopardy to the states. Double jeopardy protection simply means that the government cannot try you more than once for the same crime. If you are acquitted or found not guilty, that's it. They can't try you again. They only get one shot at you. That's what double jeopardy is. The prohibition on double jeopardy says The government only gets one try. And so between 1937 and 1969, the court did a big flip-flop. And again, it took more than 30 years for the court to nationalize that protection against double jeopardy. And it's very fascinating to note that until 1961, only the First Amendment and one clause of the Fifth Amendment had been incorporated into the 14th Amendment or made applicable to the states. After 1961, which is relatively recent in the scheme of things, most of the important provisions of the Bill of Rights were incorporated into the 14th Amendment and therefore applied to the states. So let's start with the First Amendment. The First Amendment has our 5 most essential freedoms. We're going to start by talking about freedom of religion. And freedom of religion is discussed in 2 different ways in the First Amendment. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Establishment Clause is the first part, and what it essentially means, or has been interpreted to mean, is that people have the freedom from the state imposing any particular religion. Now, that was the basis of Engel versus Vitale in 1963, the school prayer case that was the subject of the For the People documentary. The reason it was an Establishment Clause case is because it was a school-sponsored, state-sponsored school prayer. And so the argument of the plaintiffs was that that violated the Establishment Clause because the state was coming up with a prayer and making public school students say that prayer. Free Exercise Clause is a different idea and basically suggests that people are free to practice their religion without state interference. Now, even the Establishment Clause is enormously controversial. We have a lot of different views of what precisely it means. Some people have argued that there should be a wall of separation between church and state, and that government cannot breach that wall. But if you read the First Amendment, you'll notice that there's no wall of separation mentioned. That was actually a concept that was brought to public light by Thomas Jefferson. And even today, there is dispute about exactly how high that wall should be. And as they predicted in that 1987 documentary, the question of prayer in school is one such area that still generates a tremendous amount of controversy in this country. There is also the interpretation of the Establishment Clause that it merely means that the government cannot establish a United States Church of America. And that interpretation reflects the views of a lot of the people who wrote the First Amendment. There's a sense that what they were trying to lay out here was a prohibition on the government establishing a state religion. Or you can look at it as government cannot favor one religion over another. In fact, it is not prohibited from providing funds to religious institutions, but funding or other assistance to religious institutions cannot show favoritism in terms of what kind of religious institutions receive funding and what religious institutions do not. Now, they had a really difficult time with deciding when government was violating the Establishment Clause. And in the Lemon test that came out of the Lemon versus Kurtzman case in 1973, the Supreme Court created a test. And they were supposed to apply this 3-part test to questions involving whether or not an action by the government had violated the Establishment Clause. And the 3 parts of the Lemon test were: does the government have a secular purpose? Is its effect to neither advance nor to inhibit religion? And does it entangle government and religious institutions in each other's affairs? The test, they hoped, could be fairly applied in a variety of different situations, and if any of those elements were shown to be problematic, then the Establishment Clause had been violated. And in fact, we've had a large number of establishment cases beyond Engel versus Vitale. In 1995, in Rosenberger versus Rector, the Supreme Court allowed funding of student religious groups at the University of Virginia, saying that to deny funding to a student religious group was to exercise viewpoint discrimination. So if other student groups could get federal funding or state funding, then it also had to be provided to religious groups. And of course, those who were opposed to that funding believed that it violated the Establishment Clause. What a lot of people don't realize is that the Pledge of Allegiance was not always the same Pledge of Allegiance that students say in schools today. I pledge allegiance to the flag of the United States of America, one nation, indivisible, with liberty and justice for all. Under God was added to the Pledge of Allegiance in 1954. And in 1980, or around that time, there was a challenge to the Pledge of Allegiance and to the inclusion of the words under God in the Pledge of Allegiance. And I may have been wrong on that date, don't quote me on that. But the plaintiff was a father of a kindergartner who did not believe she should have to pledge allegiance to the flag and use the words under God. He went to the court, and ultimately that case and challenge was dismissed, and it was dismissed on standing grounds. They said that because the father was divorced and he was the non-custodial parent, he no longer had standing to bring that lawsuit. But it is still a potential lawsuit because of the fact that the words under God were added to the Pledge of Allegiance specifically by Congress with the intention of distinguishing Americans from the godless communists. Now, remember we talked about the McCarthy era, where everyone was so worried about communists and communism, and that is when the pledge was changed to indicate that it also included the words under God. Now, if the lemon test worked well, they would be able to pretty cleanly determine when actions of the government violate the Establishment Clause and when they don't. But in 2005, it became very clear that's not the case, because there were two Establishment Clause cases that year. One was Van Orden versus Perry, and it involved the Ten Commandments display outside the Texas state capitol, and they upheld that. They said that was not a violation of the Establishment Clause. And then in McCreary County versus ACLU, it was about a Ten Commandments display inside the Kentucky courthouse. That they struck down as violating the Establishment Clause. And the reason I share these two things with you is because it illustrates it's very difficult to know in any given instance how the court's going to rule on establishment cases. Now we're going to talk about free exercise of religion. And the religion clause, the free exercise clause, protects the right to practice whatever religion one chooses. That includes the right to be a non-believer. And that was the basis of Newdow's challenge to the Pledge of Allegiance, that he was an atheist, he was raising his kindergarten daughter to be an atheist, and having the words under God in the pledge violated the Establishment Clause. Well, we also had the Pledge of Allegiance at the center of an early free exercise case in 1943. This was in West Virginia State Board of Education versus Barnett. And this was a case where children from Jehovah's Witnesses families were refusing to say the Pledge of Allegiance because their religion forbid it. Jehovah's Witnesses believe that you cannot swear an oath to anything but God. And the court upheld their right to do that in 1943. They said children of Jehovah's Witness families do not have to say the Pledge of Allegiance. They can refuse to salute on the grounds that their religious faith does not permit it. So that was a free exercise case where the children were excused from participating in the pledge. There have been lots of free exercise cases, including Cantwell versus Connecticut in 1940. The Cantwell case was important because it put time, place, and manner restrictions on free exercise of religion. And we're going to see that those kinds of restrictions were determined by the court to be necessary. And they reflect that we do not have an absolute free exercise of religion right. It is balanced against other needs of the state. Other recent exercise cases include Holt versus Hobbs. In 2015, there was a prison policy that required all prisoners to shave their facial hair, and it was challenged by a Muslim prisoner who grew a facial beard because of his religious faith, and the Supreme Court upheld his right to do that. They struck down the prison policy and said that this individual had that right because it was a sincere and legitimate expression of his religious faith. Also in 2015, we have the EEOC versus Abercrombie and Fitch. This involved the Abercrombie and Fitch company that told one of the people they had hired, a Muslim woman, that she could not wear her headscarf because it violated their dress code ban. That ban was struck down by the court. And they basically claimed that, in fact, a ban on headscarves was religious discrimination, and it failed the free exercise case. First Amendment also includes freedom of the press. Congress shall make no law abridging the freedom of speech or of the press. So we've got religion, freedom, establishment clause, and free exercise. We've also got freedom of speech and free press. Now, I've already talked a little bit about the marketplace of ideas and why it's necessary for a democracy to have free, open, competing ideas out there in the marketplace of ideas. And in 1938, the Supreme Court said that legislation that restricts speech is to be held to a more exacting judicial scrutiny. And this higher standard of judicial review is called strict scrutiny. It basically means that if the government tries to restrict speech in any way, shape, or manner, they have to meet a very high standard before they can do that. And there have been a lot of important court cases that have helped us understand the limits of free speech. Just like free exercise isn't absolute, neither is free speech. In 1919, there was an important case called Schenck versus the United States. And in that particular case, it involved a man named Schenck who was opposed to World War I and American involvement in World War I. And he was standing out on a corner handing out pamphlets protesting the war and the draft and encouraging resistance to the draft. He was arrested and tried under the Espionage Act of 1917. Schenck upheld the Espionage Act, and they concluded that what that man was doing constituted a clear and present danger to the national security of the United States, and therefore it was not protected speech. So the Schenck case essentially established the clear and present danger exception to free speech. Other important court cases include today's standard with regards to what constitutes free speech, and that is the imminent lawless action test. The imminent lawless action test was set up by the court in Brandenburg versus Ohio in 1969, and it essentially ruled that speech is only restricted if it goes beyond mere advocacy or words to create a high likelihood of imminent disorder or lawlessness. This case came about because of a speech by an avowed communist, and he had been arrested for advocating the violent overthrow of the United States. That is basically what communism says, is that ultimately capitalism will be overthrown and then a communist dictatorship, etc. Now, he did not specifically advocate for violence, but he spoke of this communist desire and had been arrested. His arrest was invalidated, and the court created the imminent lawless action test. Now let me see if I can explain to you the difference between imminent lawless action and advocacy. If I were to tell you that I was a communist and I advocate the violent overthrow of the United States government, that would not violate the imminent lawless action test. On the other hand, if I said, oh, and by the way, I know where we can get some bombs and some guns and we can go blow up the federal building, that would violate the imminent lawless action test. So speech can be restricted if it goes beyond mere advocacy or words to create a high likelihood of imminent disorder or lawlessness. There are other limits to free speech, and they include fighting words. In the case of Chaplinsky versus New Hampshire in 1942, they said that speech is protected until it moves from the symbolic realm to a direct incitement of damaging conduct. And what they said fighting words were words that would cause a reasonable person to respond with violence. So fighting words were an exception to your free speech rights. In Dennis versus the United States in 1951, there was another ruling that there was no substantial public interest in permitting lewd, obscene, profane, libelous, or fighting words. However, since the 1950s, the court has reversed almost every single conviction based on arguments that the speaker used fighting words. And as you will note in the assigned reading on civil liberties, fighting words are not an exception to free speech that prohibits hate speech. Hate speech is not prohibited under the Constitution, under free speech. And again, the reason that happens is because it is mere advocacy, not imminent lawless action. So fighting words are really hard to ban because the target has the option of ignoring them. And hate speech is also very difficult to ban because it is the expression of a political idea. When words leave the realm of thought and move into direct and immediate action, then their speaker can be held accountable. In 2016, we had this very interesting case called Mattel versus Tam. And this case involved a young Chinese American who wanted to form a punk rock band and wanted to call the punk rock band the Slants. Now, the Slants is a racial slur against Asian Americans, but he wanted to embrace that term and use that for his punk rock band, but he was denied the right to use that term because it was considered a slur. Political satire is protected speech, and we know that that has been the case ever since the case of Jerry Falwell. Jerry Falwell was a very well-known religious conservative back in the 1980s, and he was satirized in Hustler magazine. I'll let you take some time and read the small print here, but he was essentially it was a parody ad that was put in that did not flatter Jerry Falwell. And Hustler published that ad parody that featured a fake interview and a picture of the Reverend Jerry Falwell. Falwell sued Larry Flint, the publisher of Hustler magazine, for libel, invasion of privacy, and intentional infliction of emotional distress. And the court upheld the right of Hustler, and they basically said that the parody was within the law because reasonable people would not have interpreted it as fact. And in fact, political satire is protected speech, even if the subject of that satire doesn't like it or doesn't get it. And in that particular case, the court prohibited public figures from suing for compensation for intentional emotional distress. And so that might help you better understand why we have such a rich tradition of political satire in this country and why political satire is protected speech. Other forms of speech are conditionally protected. Student speech is conditionally protected speech. Back in 1969, a number of high school students in Iowa were opposed to the Vietnam War, and they decided that they would wear black armbands to high school in silent protest. When they did that, they were expelled. They were accused of disrupting the educational environment, and they were told that they did not have the same free speech rights as adults. But the court disagreed, and the court in Tinker versus Des Moines upheld the right of those students to engage in this silent political protest of the Vietnam War. The case of what limits should be imposed on student speech have come up regularly throughout our history. There have been cases which have ruled that students do not have free speech rights to engage in sexually suggestive speech. So you can be punished if you engage in sexually suggestive speech in an academic context in high school. Now, a recent case involved bong hits for Jesus. This was a case where a public school student went on a field trip and unfurled a banner during the field trip and was suspended. The student was Joseph Frederick, and here's a picture of what he did. And Joseph Frederick essentially made the claim that he had a First Amendment right to make this statement, and the court disagreed with him in 2007. They said that even though they were on a field trip and not in school, that his decision to unfurl this banner was not protected speech, because high school students get much more limited protection than adults when it comes to speech. Other forms of speech are also not nearly as strongly protected as political speech. Commercial speech is one example. The government needs only have a rational basis to ban an advertisement. So, for example, in Lorillard Tobacco versus Riley in 2001, a Massachusetts ban on all cigarette advertising violated the First Amendment right of the tobacco industry. So they had some speech rights that had been violated by a blanket ban. And we know also that in Citizens United in 2010, the Supreme Court declared that the law that banned corporate funding of independent broadcasts was unconstitutional. And that allowed a large amount of corporate money to get into American politics. In addition to the speech that comes out of one's mouth or that is written down, there is also a protection for symbolic speech. And symbolic speech is nonverbal speech in the form of action, such as picketing, flag burning, or wearing an armband to signify a protest. Flag burning was upheld to be a protected form of speech by the Supreme Court in Texas v. Johnson in 1989. That case was as unpopular as the prayer case way back in the 1960s. Most Americans do not approve of burning the American flag. But the Supreme Court said that it is clearly symbolic speech, that it clearly is a protest, and it is protected speech, and they struck down all of the laws in Texas and in the country that made burning the American flag a crime. We also have the situation involving the Westboro Baptist Church, which we saw in Snyder versus Phelps in 2011. If you don't know who the Westboro Baptist Church is, you may have seen them in the news. They are a group that likes to picket the funerals of returning Iraq and Afghanistan veterans. And they are essentially anti-gay and believe that the United States, by recognizing gay rights, has essentially damned the United States to hell. And in this particular case, they had picketed a funeral for a young man who had died in service, and his father sued to try to squelch that speech because it was offensive and very emotionally traumatizing for the families. But the Supreme Court again stood up with this very unpopular group, the Westboro Baptist Church. The Reverend Phelps is the leader of the Westboro Baptist Church, and they allowed it. They said that yes, it was very unkind speech, and yes, it was very emotionally traumatizing, but it was nonetheless free political speech taking place in a public place, and therefore they were not going to restrict it. Now, not all symbolic speech gets protected by the court. In U.S. versus O'Brien in 1968, the Supreme Court ruled that people who were opposed to the draft and protesting the Vietnam War could not burn their draft cards, because draft cards were the property of the United States government, and that need for the government to raise an army trumped their free speech rights to burn draft cards. So you can burn the flag, but you could not burn draft cards. Also, in the First Amendment, we have a protection for our freedom of assembly and for a redress of grievances. In 1939, we had a case called the Hague versus CIO, which gave First Amendment protection to demonstrations. So people have a right to protest in this country, and it has been specifically upheld by the Supreme Court. We have a right to assemble peaceably and to seek a redress or compensation for grievances against the government. However, just as in the case of free exercise and in speech, there are some limits placed on assembly. In its rulings, the court has allowed content-neutral time, place, and manner restrictions, and those are restrictions that limit the time, place, and manner in which a protest or an assembly can take place. At San Diego State, before 2010, they had a very antiquated free speech policy on campus, which basically said that you could have free speech between the hours of noon and 1, Monday through Friday, on the free speech steps of the old Aztec Union. And that was it. That was your total free speech rights. If you tried to assemble or have a meeting or a protest anywhere else on campus, you were in violation of that policy. And that policy was rewritten in 2010, and you have it linked to your syllabus, and what you will see is that it is a much more liberal policy. As long as your free speech and your assembly do not interfere with the educational process, you are probably protected, and your right to protest or assemble on this campus is no longer limited by a specific day and a specific time. On the other hand, if you decide to have an assembly or a protest outside a classroom and make so much noise that the teaching cannot go on, you are in violation of the university's mission, and that speech is not protected. Free speech has become a very important contemporary issue, seems to always be an issue in one way or the other. And of course, in the last fall, the decision by a number of National Football League players to take a knee during the national anthem to protest police brutality against people of color was very controversial, and it was very dramatically opposed by the Trump administration and by his treasurer, Secretary of Treasury Steven Mnuchin. He basically argued that it isn't about Democrats, it's not about Republicans, it's not about race, it's not about free speech. They can do free speech on their own time. And of course, while they are getting ready for a football game, taking a knee was a form of protected political speech. Now, it is important to note that First Amendment assembly is often unpopular. Take a look at this survey data from the 1960s. Do you think that the demonstrations by Negroes on civil rights have helped more or hurt more in the advancement of Negro rights? In 1966, many people looked at the civil rights movement very negatively, and they thought that it hurt it. We see very similar reactions today to the Black Lives Matters movement and to the decision by professional athletes to take a knee during the national anthem as a form of protest against police brutality in communities of color. And the fifth freedom that is in the First Amendment is freedom of the press. Freedom of the press means that government cannot exercise censorship, the attempt to block the publication of material that is considered to be harmful. The technical name for that is prior restraint. So prior restraint means censorship, and the First Amendment bans censorship. In Neer versus Minnesota in 1931, the First Amendment guarantee to a free press was incorporated to the states in Neer versus Minnesota. A very important free press case took place in 1971 and involved the Pentagon Papers. The Pentagon Papers were released by a Pentagon contractor named Daniel Ellsberg. He became aware that the United States government had been lying to the American people about the Vietnam War over the course of several decades, and he photocopied evidence and gave it to the New York Times. The New York Times was going to publish it when the Nixon White House demanded that they stop. They claimed that it was a national security issue, and they demanded that those papers not be published. Well, the case went straight to the Supreme Court, and the Supreme Court sided with the New York Times and Daniel Ellsberg. The court basically said to the president, you need to prove that it would hurt national security to release the Pentagon Papers. They may be embarrassing to the government, but that's not the same thing, and they need to be released. So there's actually, I think, a film out right now about the Washington Post, which was also involved in attempting to get the Pentagon Papers out to the American people. I guess what we need to talk about now are some of the things that are not protected speech. And pornography and obscenity are not protected speech. The problem with pornography and obscenity is that they're difficult to define, and therefore they're very difficult to regulate. Justice William Brennan provided a definition. He said that pornography or obscenity is speech or writing that appeals to prurient interest. In 1964, Justice Potter Stewart wrote that pornography was impossible to define, but added, I know it when I see it. Well, neither of these were very helpful in determining when a particular work violated the ban on obscenity or pornography. And so in 1973, the court decided to make a test, and this was called the Miller test. And the Miller test was, again, a three-pronged test that was supposed to help the court look at specific instances and make a determination about whether they were protected speech or whether they were obscene. Let's stop here, and we'll pick up in part 2 with the remaining 9 amendments.